Hello, welcome to the University of York. I hope you're somewhere nice and warm on this cold evening and ready for some excellent advice on will writing and estate planning from local York solicitors Crombie Wilkinson. My name is Marisa Bailey and I'm the Legacy Manager here at the University of York, and I'm your contact if you'd like to discuss leaving a gift in your will to the university. Just to give you a couple of examples of legacy gifts the university recently received, we've had a gift to support archaeological travel bursaries, which is really exciting. Another legacy gift is to go towards care experience students, which will have an incredible impact. Gifts of any size make a real difference to our students and researchers and are very gratefully received. My role also includes planning this free event in collaboration with Crombie Wilkinson. Speaking of which, I am delighted to welcome our speakers today. Richard Watson, a practicing solicitor and former senior director and head of the private client team at Crombie Wilkinson, and Belinda Poulter, who is a director at Crombie Wilkinson. They've very generously volunteered their time for us this evening, and I'd like to take this opportunity to thank them for their help and expertise. A little bit of housekeeping before we start. The session is being recorded, and throughout the presentation, your video will automatically be switched off and your microphone muted. The talk will last for about an hour, with time afterwards for Q&A. Questions should be typed into the Q&A box at the bottom of your screen, and I will read them out for you after the presentation. Please don't worry if your question doesn't get answered, as we will respond to those in a later email. If your question is more complex, I would advise you to make an appointment with Crombie Wilkinson. Finally, from me, I've got a very special opportunity for all our guests joining this live webinar, a chance to win a free simple, single or joint will from Crombie Wilkinson. To begin with the chance of winning, all you have to do is add your details to the post-event survey, which will automatically pop up on the screen after you leave the webinar. Now, let me hand you over to our first speaker, Richard Watson. Richard, over to you.
Thank you very much, Marissa, and a very warm welcome from a very wet York tonight. I'm Richard Watson. It's been my delight to be participating in these events for very many years when I was working as a solicitor, and now that I am retired. We're going to spend the next hour going around those aspects in respect of making wills, why you do so, some of the things you can do to make your life easier and to make your beneficiaries easier, and also hopefully to save a little bit of tax. So the first question is, why make a will at all? It's quite astonishing. Something in the region of 2/3 of people in the United Kingdom do not have wills. Well, the first reason for making a will is that you can choose to whom you leave your property. In England and Wales, we have what's called testamentary freedom. That is, broadly speaking, we're able to leave our property to whom we like. There are certain limitations, and we'll talk about those later on. And that's in contrast to various other foreign jurisdictions. In contrast, if you don't leave a will, then the law of intestacy kicks in. The law of intestacy dictates who inherits your property when you have died and there is not a will in place. And we'll talk a little bit more about that later on. The next reason for making a will is that it gives your executors immediate authority to act. Your executors are those people who stand in your shoes after you have died and will carry out your wishes in accordance with your will. The will itself is the authority for the executors. Now, it is fair to say that to draw down lots of money from banks, building societies, to sell houses, normally to deal in stocks and shares, that authority has to be authenticated, and the authentication process is to apply to the probate registry, and that's part of the High Court, for something called a grant of probate. But for dealing with the little things of life, which so often need fairly urgent attention after somebody has died, the executors have the assurance of immediate authority. Next, it can be the case that you can make an amount of tax saving by arranging your affairs in certain ways. And we're going to touch on that later on this afternoon. But suffice it to say, by, say, the creation of a trust, then quite significant tax saving can be made. Next, there's the question of young adult children. The law of intestacy, the law of England and Wales, is that people become an adult at 18 and therefore they're capable of inheriting. Anybody who is a beneficiary below the age of 18 will find the money is held in some form of trust envelope. And that's not to say necessarily that they can't have access to any of it, but there is a degree of control. The law of intestacy would allow an adult child to inherit at 18. Some people would be of the view, particularly if a large amount of money is involved, that 18 is an age which is a little on the young side, and they would prefer to delay it to, say, 21 or even, say, 25. Now, executors and trustees do play a part in the will scene. Executors are those who stand in the shoes of the deceased after somebody has died. If there is an ongoing trust arrangement under a will, then those executors, after the immediate administration has taken place, and that in itself can take some months, sometimes even some years, if a trust is ongoing, they are likely to be the first trustees to manage the trust. As I say, executors are there to wind up the estate. Trustees are there to manage any trust fund which the will has created. Going back to the example of the child underage, that money is going to be held on a trust basis. The next point to have consideration to is in respect of guardians. Now, it has to be said that whereas a gift in a will, an appointment of an executor, is binding, anything we say in a will concerning the guardianship of children can always be overridden by the courts if the courts come to the conclusion it is not a suitable arrangement. But it's a very good way of indicating whom you would wish to be guardians of children who are under the age of 18. Now, if we look at the types of legacies which appear in a will, there are specific gifts, things like watches, jewellery, furniture, perhaps stocks and shares, could be a family heirloom, an item which you wish to pass down the family line. Then there are pecuniary gifts. Those are gifts of specific amounts of money. They may be to individuals, but also they may be to charities. Giving to charities is a very tax-efficient way of leaving money. We all know that if we give to a charity out of our income, there's gift aid and there are tax advantages, so the charity can recover basic rate income tax. And if you're a higher tax payer, you can recover the margin. Well, it's a fairly similar situation so far as a gift in a will is concerned, in as much as any gift to a charity is going to be exempt from inheritance tax. Inheritance tax, broadly speaking, is a tax at 40%. So a very efficient way of doing things. What's left in your estate when we've dealt with specific gifts and pecuniary gifts is what's called the residuary. of the estate. By definition, when you're making your will, you're never going to be quite sure how much there is going to be, because obviously all our wealth, so to speak, goes up and down as money comes in and as money goes out. Frequently, because it is of a varying amount, people will say that if a residuary gift is going to more than one person, they will express the person's interest as a percentage rather than a specific amount. But there's no reason why you can't do it as a specific amount, although being logical, that means it is a specific gift in most cases anyway. Finally, a will is a very good place to record your funeral wishes. It's the first place executors are likely to look after somebody has passed on, assuming that they haven't had a conversation in advance. It can be that you might put a very simple direction that you wish your remains to be buried or cremated. It might be that you wish to be more specific, whether a service is religious or secular, what you want to be involved in the service, or indeed no service at all. If it becomes slightly complicated, it's probably best doing a separate letter away from the will, and then just making a reference in the will that there will be a separate letter. Now, that's a whistle-stop tour around the question of why make a will and the broad structure of a will. I've talked about trusts, so I'm going to hand over to Belinda now, who is going to talk in more detail about various types of trusts.
Thank you, Richard, and good evening, everybody. So Richard has given you the basics of what makes a will and what the various aspects that you can include in your will. Many people's circumstances are more complicated, and there are other things that need to be considered when they make a will. When you make a will, you can include trusts in those wills. The will contains the trust, and the trust isn't actually set up until you pass away, but you can put the framework of the trust in the will. There are two main types of trust that we would include in a will, and I'm going to tell you a little bit about the two types of trust, how they work, and when you might use them. So the first trust that we would prepare in a will is called a life interest trust. The life interest trust has two types of beneficiaries. It has the life tenant, they're the person who has the use of those assets for their life, and it has remainder beneficiaries, who are the people who will receive those assets once the life tenant has passed away or the trust comes to an end for other reasons. This type of trust can be particularly useful for people who are looking to try and preserve a part of their estate in case they move into residential care. So, for example, if you make a will, if you are a partnership, a couple, a husband and wife, you're in a civil partnership, you can make wills which contain a life interest trust. The life interest trust would take effect on the first to pass away, and you would give your spouse, civil partner, the right to use those assets for the rest of their life. They would have the right to have the income off those assets if they were investments. If you were looking at a property, they would have the right to use that share of the property, for example, to live in. But because that person only has the right to use those assets for their life, further down the line, it means that the capital isn't available to them. So from a point of view of that person receiving residential care, the capital value of those assets would be preserved for your remainder beneficiaries. As I mentioned, you can use your property in a life interest trust, and leaving a share of your property into a trust is a good way of looking at this. Life interest trusts can also be very useful if people are on second relationships, second marriages, again, second civil partnerships, and they have children from their first relationship. Whilst if you're entering a new relationship and you are buying a house together or you're living together, you are confident that your new partner, spouse will uphold your wishes when they pass away. You've always got to be mindful that people can change their wills whenever they want. So if you pass away first in that relationship and leave everything to your partner, spouse or civil partner, they may change their will at that time and leave all of the assets to their own children. None of us want to think like that, but it can happen, and we've seen it happen. So again, the use of a life interest trust means that you can preserve some of your assets while still allowing your partner, spouse to have use of those assets. The capital again would be preserved and would pass where you wanted it to. It's quite a simple trust in the way it works. It's quite easy to set up and get going, but can have a really good effect and a lasting effect on your estates going forward. There are many things that affect us these days that can also make you think about your will and make you cautious of leaving money to certain beneficiaries. You might have children who have disabilities, physical or mental disabilities. You may have children who are starting to go through divorce proceedings, and again, you want to preserve your assets. You don't really want them to become part of that divorce if you passed away at that time. You may have children with businesses that perhaps aren't doing very well, and you're concerned that they may move into bankruptcy. And again, you wouldn't want an inheritance to pay the trustee in bankruptcy. Equally, you may have children that are extremely successful in their careers and actually don't need the money that you would want to leave them, but they have children of their own and they may wish to pass that money on to their children, or that might be a consideration. In circumstances such as that, you could use a trust called a discretionary trust. The term discretionary describes this type of trust. It's a trust whereby you would put monies into a pot, for example, and that pot would have a group of beneficiaries. Anyone from that group of beneficiaries, which could be your children, it could be your grandchildren, it could be nieces, nephews, it could be anybody that you may wish to consider to benefit from this pot of money. All of those people become potential beneficiaries, but none of them can actually demand a share of that trust. It is for the trustees to decide who gets money from the trust, when and how. It's important, of course, with this type of trust to make sure that you've chosen your trustees wisely, because they are going to be making decisions, the onward decisions. It may be, for example, if one of your children is divorcing, their money stays within the trust until all those proceedings are finalised, and then the trustees can make that decision to pass money on to them so that they can use it. Again, going back to children who maybe don't need your money, and if their inheritance might put them in a problem with inheritance tax, that money can remain in the trust and be used for their children if that's what they wished. And in particular, if you have children with disabilities or other beneficiaries with disabilities, monies that are retained within a discretionary trust will not affect any means-tested benefits that they may receive. So, for example, if they are receiving certain benefits and they received an inheritance from you, those means-tested benefits would immediately stop. Their housing may then become that it needs to be paid for. and this may cause them issues going forward. Sometimes people can manage the amounts of money that they receive as part of their benefits. They know they need to put some aside for their utilities, they've got a bit to spend. But if they then came into a large amount of money, this may make them vulnerable. They may suddenly find they've got lots of extra friends, but equally they would have to pay more bills and that money would get used up very quickly. By enabling to keep that money in a trust, that money can be paid to those beneficiaries for expenditures if they need a new computer, if they need a new television for their house, or if they get the opportunity to go on a holiday. Monies out of the trust can be used to pay for those things, the nice things in life, while they use their benefits for their everyday things. So there's a lot of flexibility with a discretionary trust as to who they're for and how that money's paid out. They're not the simplest of trusts to manage, and the trustees do need to be careful about how the trust is managed and how the trust is run. But there are a lot of circumstances out there where a discretionary trust is a good trust to use. There is a type of trust specifically aimed at disabled people, which is called a disabled or vulnerable persons trust. That trust has different tax benefits for the disabled person, and then becomes a discretionary trust when that person no longer needs the money. And so particular care needs to be taken for the circumstances of including a discretionary trust in a will, in case a disabled person's trust would be the better trust to use. A type of discretionary trust that we used a lot in the past, but not used so much now, is called a nil rate band trust. Previously, everyone who had a nil rate band, if they died first and they had a surviving spouse or civil partner, that nil rate band would not pass to that person if they left all of their estate to them. So a nil rate band discretionary trust was a way of preserving the nil rate band so that you could take assets out of the estate. So the monies were put into a discretionary trust. The spouse or civil partner could be a beneficiary of that trust, but the assets were not included as part of their estate when they passed away. That type of trust also allowed assets which may have large gains, such as share portfolios or other assets that may increase in value. The increase in value would then occur inside the trust and not in the estate of the second to pass away. So there's a lot of flexibility within your will to include trusts depending on your circumstances. And if you do have circumstances that don't always fit a very simple, straightforward will, it's always worth exploring if a trust would meet your needs and make you feel much more comfortable about how you leave your estate. If you don't have a will, there are measures, there are laws which explain what would happen to your estate if you've died what's called intestate. Richard's going to talk to you now a little bit about what would happen in that situation.
Okay, thank you very much, Belinda. And I'm not quite sure if the camera's switched or not, but I'll continue. Intestacy, as we've said, it's the estate without a will, and roughly speaking, 2 or 3 estates within the country are intestate ones. I mentioned before how the will itself appoints executors, and those executors can act straight away. The thing is, if there aren't any executors appointed in the will, there's nobody who can act straight away. And what has to happen is that somebody closely involved, a near relative, say, will apply to the probate registry for the equivalent of a grant of probate, but it's called a grant of letters of administration. And that grant itself appoints that person an administrator. And the administrator is playing the same role as the executor. The very earliest you're going to get a grant is going to be some months after somebody has died. And accordingly, it does leave the estate very much up in the air for a long period. And whilst people will undoubtedly make decisions of a minor nature, they are doing that against a background of not really having the authority to do it, albeit that they're acting with the best of intentions. So, whereas with a will you choose who inherits from you, without a will, the law intervenes. An Act of Parliament from 1925 called the Administration of Estates Act dictates what we call the pecking order. So if you are married or in civil partnership with no children, the surviving spouse or civil partner will inherit everything. If you are married or in civil partnership and you have children, the spouse civil partner inherits all personal possessions and something called a statutory legacy, and that's the first £322,000. It is an amount which goes up from time to time, but for the moment it's 322,000, which I think a lot of people think it's not a rounded figure and therefore slightly curious, but be that as it may. After that, if there's anything left, a half of it goes to the surviving spouse or civil partner, and the other half goes to the children, and it goes to the children equally. And should a child have died and in turn left children, i.e. grandchildren of the deceased, then the grandchildren would step into the shoes of the parent and take their parent's share. Sometimes it works, sometimes it's an utter disaster, and it leaves a surviving spouse with, say, young children in a bad financial position and with a rather unpleasant atmosphere, in as much as the spouse basically has to make an application to the court to take what the children have inherited in order to keep the family going. Not a desirable thing to happen, but certainly in my working life, I saw that situation on a few occasions. Now, if there's no spouse, civil partner, and no children, including grandchildren, great-grandchildren, etc., those we call the lateral descendants, the issue, then the estate will go to other specified relatives in a specific order. But broadly speaking, all those people who are going to inherit must be the descendants of your grandparents. That's what it boils down to. So it does include aunts and uncles, grandparents' parents. And if none of those people exist, the estate is said to be bona vacantia, one of those little Latin tags which lawyers so like, literally meaning vacant goods. And it means the estate goes bona vacantia. At least in theory, it goes to the Crown. In reality, it goes to the Treasury, it goes to the government. And it is a task of one of the senior law officers in the government to look around as to people who might have a moral entitlement. But what you may say is a moral entitlement is not necessarily what that law officer would say. You've probably realised by now that if we have an unmarried couple, then we have a massive problem if there is an intestacy. If we look at statistics now, more people are living in an unmarried relationship than in a married relationship. The Admin of Estates Act makes no provision at all for the unmarried partner. There is a saving provision, something called the Inheritance Act, the Inheritance Provision for Family and Dependents Act, 1975. And that also links into what I said at the opening of the lecture, that broadly speaking, we have a freedom to leave our property as we wish to, but there is a little bit of a safety net. What the Inheritance Act says is that for certain classes of people, if the will or the fact that there isn't a will, an intestacy, does not make proper provision for them, then that person can make an application, excuse me, under the Inheritance Act in order for relief. The classes of people who can apply are these: the spouse, civil partner, and they are entitled to a reasonable sum. Frequently, courts treat it as though a divorce is taking place, using the same principles. Then there is the unmarried cohabitee of at least 2 years. You must establish 2 years. They are entitled to reasonable maintenance. Now, what is a reasonable sum and what is reasonable maintenance can be a very different figure. The third and fourth classes are children who are dependent on the deceased and anyone else who is dependent, and basically they are entitled to reasonable maintenance. Now, I've summarised the provisions of the Act there. There are subtle differences, but broadly speaking, it's reasonable maintenance unless it is the spouse, whereupon they are entitled to a reasonable sum. It means you have to bring court proceedings. You're only entitled to bring them within a 6-month period after a grant has been issued, unless the court gives you special permission. Invariably, in the happy family situation, it's a traumatic time for everybody. To have to start court proceedings is the last thing people want. Even if it's the unhappy family, where the family is in dispute, it's equally an unhappy time to start court proceedings. So if nothing else, if you are in a long-term relationship and or you have children, please do make a will. That is intestacy in a nutshell. And Belinda would now like to talk about one of the two certainties of life. If one is death, the other is taxation. And so it's inheritance tax from Belinda.
Thank you, Richard. I really don't like talking about inheritance tax, but it is something that we all need to be aware of when we're thinking about our will and we're thinking about our mortality. So I always like to start this little section off with quite a large figure, which is the inheritance tax receipts. So in the 9 months from April 2025 to December 2025, the inheritance tax receipts were 6.6 billion. And that's up 232 million on the 9 months of April to December 2024. So I always think that's a really shocking figure. And I always think that's going to go up next year, as it has done every year for the last 4 or 5 years that I've been checking these figures. So what can we do about inheritance tax? Well, there's not a great amount we can do, but we need to be aware of what the exemptions are, what we have got to use, because it helps us consider our estate. So everybody has a nil rate band. The nil rate band is currently 325,000, and that means that you can pass assets to any beneficiaries up to the value of 325,000, and that is, it's classed as being taxed at the rate of 0%, so it's inheritance tax free. If you pass assets over that amount after your death, then the assets above 325,000 will be taxed at 40%. Now, there is a saving provision now called the transferable nil rate band. What this means is that if on the first death you transfer all of your estate or any of your estate to your surviving spouse or civil partner, you also pass them either your full nil rate band, so a full 325,000, or if you've left assets to other non-exempt beneficiaries, then a proportion of your nil rate band, and it can be proportioned down. So that would mean that on the second of a spouse or civil partner to pass away, then you have £650,000 worth of assets which can be passed without being taxed, so taxed again at 0%, and anything over that amount would be taxed at 40%. On top of that, any transfers between spouse to spouse or civil partner to civil partner, so for example, if your will left everything to your surviving spouse or civil partner, there would be no inheritance tax to pay. What should be borne in mind, however, is that if you leave all of your assets to your surviving spouse or civil partner, then that would swell their estate. So when they pass away, their estate would be taxed on all of those assets. If that's over the 650,000, which would be the joint exempt amount, there would be 40% to pay on the assets over that amount. There are also an exemption called the residence nil rate band. This only applies in certain circumstances. The residence nil rate band applies if you are leaving a property, your residence, your main residence, to a lineal descendant. Lineal descendants is classed reasonably widely. It includes your children, your grandchildren, your great-grandchildren. It also includes the spouse of any of your children if your child had passed away. It also includes your stepchildren if you are or were married to their parent at the time of your death. It includes children you have adopted. It also includes children you may have fostered. So it's quite a wide exemption, but it only applies to lineal descendants. So for an example, if your house, your residence, passes to your surviving spouse or civil partner and then passes to your children, you would be able to claim the residence nil rate band. The residence nil rate band is currently 175,000, and again this can be transferred to your surviving spouse or civil partner, so they would have an additional 350,000 worth of assets that could be passed without inheritance tax being paid. But that 350,000 only applies to your residence. If your residence isn't valued at 350,000 at the time of your death, you can only claim up to that amount. There are, however, some provisions called downsizing provisions. So, for example, if you had a house worth 750,000, but because the surviving spouse or civil partner was then on their own and they chose to downsize to a smaller property, If the smaller property was worth only, let's, for example, say £200,000, you can potentially look back and claim the downsizing allowance to claim the whole 350,000. This would also apply if you had sold your house and moved into residential care. You can look at the value of your property that you sold before you moved into residential care and still claim the residence nil rate band against it. One point to always bear in mind is if your total estate is worth over 2 million, the residence nil rate band will be decreased by an amount. And in fact, if it's over 2 million, there will be no residence nil rate band available. If your total estate is worth between 1 million and 2 million, the residence nil rate band will be reduced. But it's a very useful addition to the nil rate band and the transferable nil rate band, meaning that potentially you could pass £1 million worth of assets to beneficiaries and direct descendants, depending on the residence nil rate band, after your death. One thing that can affect all of these exemptions that I've talked about, and I'm going back to this, which Richard has also touched on, is whether you are married or not married. If you are not married or in a civil partnership, you would lose the spouse exemption, which means all assets that you pass to your surviving spouse or civil partner, which is free of inheritance tax, would be lost. You would have your own nil rate band, you would potentially have your own residence nil rate band, but you would not have any transferable nil rate band or transferable residence nil rate band. This only transfers from one spouse to another or one civil partner to another. So again, we don't like to say that marriage could be the best thing. Richard and I always laugh when we say this, but there are inheritance tax savings that can be made in that situation. Another point to mention in terms of the residence nil rate band and stepchildren, you may class children as your stepchildren, but if you aren't married to their parent, then again, that residence nil rate band would be lost if you were leaving a share of the residence to them. So it is something to consider. In fact, both Richard and I have had clients in the past where we've been having inheritance tax discussions where potentially one of them has had a diagnosis which is not very favourable. And we have concluded our discussions by saying, do you know, you really ought to get married in these circumstances. And I think both of us have had a phone call saying we did it, we got married, and then they're extremely grateful for that advice. So it's always a consideration is to look at the size of your estate when you're preparing a will, to look at how you think you want it to pass and make sure that you can gain the exemptions that are available at that time. All of these exemptions that I'm talking about apply to people who are resident and domiciled in England and Wales. If you have a spouse who is not resident or domiciled in England and Wales, then not all of these exemptions apply. I'm not really going to talk about that here, but you do need to take some specific advice as to the tax implications of passing assets to non-domiciled spouses or civil partnered. So that's a brief overview of inheritance tax and how you can take some steps to make sure that it is mitigated. Richard's just disappeared because I was just about to say Richard's going to talk to you a little bit more about how you can use giving and lifetime giving to help in respect of inheritance tax. Thank you, Richard.
Hello there. Yes, thanks very much indeed. Well, Belinda's delivered the bad news as to what the inheritance tax framework is likely to charge you. I'm going to run through very quickly some of the avoidance measures. First and foremost, anything given within 7 years of the date of your passing away should be exempt from tax. And indeed, even if it is less than a 7-year period, there is a gradual reduction in the tax charge. So for the first 3 years after the gift, there is no exemption, and the value of the asset or the money involved will be referenced back to your estate for inheritance tax to be paid. After that, over the next 4 years, there is an abatement of 20%. So by the time you get to the 7-year anniversary, the tax charge is wiped out. The only thing I will say on this is that it does become a little complicated if you're in the 3 to 7 year period, because the giving will start to eat into the nil rate band. A little bit complicated, but we're very happy to talk that through with anybody who'd like to know the greater detail. And of course, once you get to the end of the first 7-year period, there's nothing to stop you doing it again. So if you are in a comfortable position as you get into what I might call early later life years, and then is a very good time to review whether or not you can pass over assets to the younger generation. Now, there is an annual allowance for everybody of £3,000. You can give £3,000 to one or more people, and it will be exempt. If you haven't used last year's allowance, then you can use that as well. So for a couple who haven't used last year's allowance, there's £12,000 with an ongoing £3,000 a year. And if you think about it, for a couple over, say, a 10-year period, it's a way of getting £60,000 away from the joint estates and to the younger generation or whoever. There is also an exemption for any small gift of up to £250. So, again, if it's a large family and you want to dissipate some money at Christmas time, birthday times, it's one of those things to bear in mind. Now, on the marriage of a child or a grandchild or anyone else, in fact, again, there are certain concessions. For a child, it's £5,000. For a grandchild or a great-grandchild, it's £2,500. And it's £1,000 for anybody else. Perhaps less so now than when inheritance tax and its predecessor tax, capital transfer tax, came in. But a richer younger generation did sometimes maintain a poorer older generation. And we've had a long-standing exemption of gifts out of income. In order to qualify for this, there has to be a regular pattern of giving. A once-off amount will not get you over the hurdle so far as this exemption applies. So there has to be a pattern of giving. It doesn't have to be on the same date every so many months or so many years. It can have a random nature, but there must be a pattern of giving. And it must be out of surplus income. So what it does mean is you have to do quite a lot of evidence gathering. You have to have the evidence there to show that the amount you're giving is surplus to your needs. And also, you have to demonstrate the pattern of giving. But again, it's one of those allowances which can mount up to a significant exemption. So moving on to charitable giving. I've already said how generous tax relief is when it comes to charitable giving, and income tax is the classic example there. Anything you give to a charity, and please bear in mind the University of York is a charity, is going to be exempt from inheritance tax. Better still, if you give at least 10% of your estate to charity, the tax rate on your estate drops by 10% to 36%. It's not, tax isn't charged at 40%, but at 36%. And I'll leave you to go away and just do the calculations, how much benefit you can give to a charity, a university or other charities, by going to the 10% figure, and comparatively how little tax is involved. Also, I spoke a few moments ago, the 7-year gift rule. Of course, that doesn't apply to a charity. So you make the gift to the charity now of a significant amount of money, and in say a year's time, you sadly pass on. Again, there's going to be no clawback into your estate in respect of that money which has been given. I'm going to lump together a few things now, something called business property relief, agricultural property relief, AIMS investment, and pension investments. They have been used in the past as tax avoidance schemes. When the new government came in 18 months or so ago, in their first budget, they've radically changed things. Business property relief, quite simply, that is property owned within a business, and property in an agricultural enterprise similarly, used to attract very significant reliefs. Those reliefs have changed significantly. There are still reliefs there. I'm not quite sure whether we've seen the end of the political story on this one. So it is something to bear in mind, and particularly to bear in mind as to whether or not you retire out of the business. If you remain in the business owning property, you might be able to qualify for the relief. These are matters to talk over with your business advisor, your accountants, because they need to be looked at in fine detail. But there is the potential for still quite a significant tax savings. The AIMS investments, AIMS stands for Alternative Investment Market, and covers some unquoted shares on the stock market. You have to have held those for 2 years, and you used to be able to get 100% relief so far as they were concerned. It has now been reined back to 50%, but again, it's something worth looking at if you are looking at how to reduce the tax bill. A couple of years ago, I said that one of the unforeseen consequences of the massive pension reforms back in the middle of the teens was that it made them a very attractive investment for people wanting to avoid inheritance tax. As of April next year, very, very significant changes. Unused, what effectively are private pensions as opposed to occupational pensions. Pensions where there is a lump sum of money will broadly come into charge for inheritance tax purposes, that is a significant change. If there is a surviving spouse, the charge won't bite whilst the surviving spouse is alive. Now, since they are coming into charge, going back to what Belinda said a few moments ago, as to residence nil rate band only being available, broadly speaking, to the 2 million threshold, it could well be the case your pension swells your estate and you could find yourself losing the residence nil rate band. So again, that's something to have a look at when you're planning. Many occupational pension schemes have a death in service provision. That is to say, if you pass away whilst you're still working and you haven't drawn down the pension, that a spouse, your children perhaps, will be entitled to a pension payment, and undoubtedly you will have been asked to make a nomination in respect of the pension. Now, virtually every occupational pension would not pay the pension benefit into your estate, but it is just worth checking that is the case. I say that because if anything is paid into your estate, it swells the value of your estate and it raises the potential or the actual tax bill so far as inheritance tax is concerned. Insurance policies, life policies, are in a similar position. Once upon a time, virtually all life policies were written in trust so that they weren't paid into the estate, but they were paid in accordance with the terms of the trust, say to your spouse and to your children. And again, it's a question of nomination forms being filled in. As years have gone by, not all life offices do that, so it's well worth checking with your insurer to make sure that insurance policies are not going to come back into your estate. Okay, that's a quick run round there. I will close on a personal story, and that is over 30 years ago now, a very dear lady left me a sum of money. She was born at the turn of the 19th century into a middle-class family. She trained as a nurse, she worked as a nurse, but she married a bank manager and it just wasn't the thing for her to continue working. And although she never said anything, it was always a sense of regret that she'd been deprived of that working experience. But she was passionate about education, and she had one lovely line: once they've taught you knowledge, they can't take it away from you. And that's been a guiding principle. So I decided many years ago that when I died, the money from this lady will go to the university, and it will be suitably increased because of inflation, because of investment returns, etc. And so that other people can have knowledge bestowed upon them, which nobody can take away. Thank you very much.
Thank you, Richard. To round off our lecture this evening, I just want to talk a little bit about capacity and what happens if you're still alive, but you lose your mental capacity. This, of course, means that you may become unable to deal with your financial affairs. You may be unable to make decisions, and you may be unable to look after your finances. It's all right talking about your wills and talking about what will happen if you pass away, but we need to think about what would happen if I become mentally incapable of managing my financial affairs, or mentally incapable of making decisions about my future. There are documents called lasting powers of attorney. These are documents whereby you choose who you would want to make decisions for you in respect of your health, in respect of your general welfare, and in particular, you make decisions as to who can deal with your financial affairs if you become unable to do so. These documents need to be made while you have the mental capacity to make those decisions. So, for example, you can choose people to manage your property and financial affairs if you've lost capacity. They're called your attorneys. So you can choose one or more attorneys to deal with your financial affairs. These should be people that you trust and also people that you feel are capable of managing finance. You can choose more than one attorney. They can be appointed what's called jointly and severally. Jointly and severally means that all the attorneys don't have to act together. So one attorney may live quite nearby and they're likely to be the attorney that does the day-to-day things, does bits of shopping, gets you money out, deals with day-to-day banking. That you may have other attorneys that live further away, but you would like them to remain involved. By appointing your attorneys jointly and severally, they can act together when making larger decisions, investment decisions, or if a property had to be sold, but it allows one attorney to act on more everyday decisions. It also means that if an attorney became ill or if an attorney passed away, the other attorneys you've appointed can still act. If you appointed your attorneys jointly, it means that if one attorney cannot act because they've become infirm or because they pass away, none of your attorneys can continue to act. You can appoint attorneys and then appoint replacement attorneys. Those replacement attorneys can only act if your main attorney has passed away, again, if they've become incapable, or if they renounce their position, if they say, I can't do this anymore. At that point, your replacement attorneys would step in. When we prepare lasting powers of attorney for people, we talk through these decisions and what they feel most comfortable with. People who have spouse or civil partner often feel that they would only like that person as an attorney. And if they then have children or if they have nieces and nephews, they would step in only when the main attorney can't. And that's when they would be appointed as replacement attorneys. So your financial LPA allows your attorneys to deal with your finances as if they were you. So they can rearrange money, they can make investments, they can deal with your investment advisors, they can sell property, they can buy property. What they can't do is write you a will. So again, you need to have made your will. Your health and welfare attorneys will make decisions about your welfare, such as where you will live, whether you receive care in your home, whether you have to move into residential care, whether you move into sheltered housing, and your welfare attorneys would be involved in those sorts of decisions. Your welfare attorneys can also make medical decisions. Medical decisions would only be made for you if you were incapable of making that decision. So any doctor or healthcare practitioner would always want you to participate in a decision or make a decision. But of course, if you wanted your attorneys there with you to help make that decision, they would be allowed to. Your attorneys for your health and welfare can also make decisions in respect of life-sustaining treatment. If you have very clear views on whether you receive treatment or whether in certain circumstances you wouldn't want to receive treatment, your attorneys can express this for you. There's two decisions that you can make in respect of your health and welfare attorneys and life-sustaining treatment decisions. Your attorneys can have the authority to make those decisions, or they can have a slightly less authority whereby they consult with doctors and healthcare practitioners, but the final decision would be made by those healthcare providers. So two extremely important documents that can ensure that if you do lose capacity, whether it be for a period of time and you recover, or you lose physical capacity, you can't sign because you've had a stroke, that there are people in place that you trust, that you want to work with, who are able to make those decisions and implement those decisions for you. If you haven't got LPAs in place, there is a resort. But what would happen is that somebody, one of your relatives or friends, would have to make an application to the court to become your deputy. A deputy is appointed by the court and they have to put forward why they are the right person to be appointed as a deputy. They might not be the person that you would want to make those decisions, and in particular, in respect of your financial affairs. It's a much more long-winded process. It can take over a year for a deputy to be appointed, and in that year you would have nobody to make financial decisions and implement those decisions. It's certainly more expensive than making lasting powers of attorney, and once you're appointed as an attorney, it is much more onerous. You have to do a report to the court every year, which says exactly what you've spent, what incomes come in, and what you've spent it on. Ideally, you would prepare the lasting powers of attorney so that they're in place and they're ready to go if something untoward happens to you. They are, we believe, extremely important documents, and really as important as making your will. If you want to talk more about any of these, we are always available to talk to you further. Thank you for listening.
Thank you, Richard and Belinda. I learn something new every single time, so thank you personally, but wonderful presentations as always. It's now time for our Q&A, and we do have quite a few. Let me just start with, let me see. Oops. Sorry, having a little problem with the tech here. Right. Here we go. With regard to health issues, I think this is one for Belinda. It's pretty much about what you've just been talking about. With regard to health issues, when a donor does not want invasive treatment once the mental capacity threshold has passed, would a living will have the same validity as an LPA, which devolves the decision to an attorney?
Living wills are now incorporated into the law, so they are a good document to prepare. Living will is more used for you to say what you want or what you don't want. The difference between the living will and the power of attorney is the power of attorney is giving certain people the authority to express those decisions for you. And people who have very strong feelings about this often prepare both to work together. So the living will actually sets out the circumstances that you wouldn't want treatment or that you would want treatment, and then the attorneys are appointed by the power of attorney to almost enact and make sure that your wishes are taken into account. The other difference is the welfare decisions. Your living will refers specifically to medical decisions, whereas your power of attorney would cover those welfare decisions that aren't necessarily medical.
Yeah, if I can just add to that, health and welfare lasting power of attorney is a far broader document than the living will. And within the lasting power of attorney, you can express wishes so far as treatment is concerned, and also you can express prohibitions as well. You're obviously you're cautioned insofar as setting things in tablets of stone, because circumstances can always be rather different.
Thank you. A question about funeral expenses. Should you say in the will that all funeral expenses are to be paid by your estate? For example, reasonable flight costs for immediate close family abroad, or should that go into a letter of wishes?
Yes, that's a very good point, isn't it? The starting point is the cost of a funeral itself is accepted as a liability of the estate. But of course, transport costs of family members coming some distance is not going to be automatically included. The thing about if you put it in the will, it is binding. If you put it in a letter of wishes, yes, the letter expresses your wish, but it doesn't have the same binding authority. So if it is important to you, then include it in your will.
Thank you. I think the next question you've already covered, I think, but I'll say it anyway. Can life insurance beneficiaries sit without wills?
Yes, because if you take out a policy of insurance, the life office will ask you to nominate those people to whom you want the money paying. So if you think of an endowment policy, which is designed to pay out during your own life, I know they're not very popular these days, but I'm sure we've got people of my age in the audience who will remember them. And you probably had an endowment policy to clear off the mortgage on your house. So in fact, but if you had died in the meantime, we would have paid out to those people you nominated. So yes, the nomination rights is something to do with the life policy itself, and not something to do with the will, really. And I add the word really because, of course, if the money were to come into the estate, then yes, it's your choice to say how the money goes. But as I said earlier on, we don't really want life insurance policies coming into estates because it swells the asset and increases either the tax bill or the risk of tax.
Okay. Another question, what happens with an unmarried couple with children if there's no will?
Well, the children will take and the partner will not take, broadly speaking, which means we're back to the Inheritance Act application.
Thank you. This might be more of a financial question. Well, can tax-free ISA stocks and shares be transferred or divided up to new ISAs for beneficiaries without selling shares? And does this apply for international shares too?
Wow. I think that's probably something outside our pay grade.
Yeah.
There are certain, Belinda will know more about this than I do, I'm sure. There are limited provisions for transferring ISAs on death. And I think it is to a spouse, but I'm not certain. Can you help, Belinda?
Yeah. You can transfer an ISA to a surviving spouse on death. You could, well, you would probably every different sort of finance house has different rules. You can certainly divide a portfolio between beneficiaries. So if you've got a portfolio of stocks and shares, a collective investment, or an OEIC, you can divide that up between beneficiaries without those stocks being sold. Quite a lot of finance companies are able to do that. It would be whether they would take it out of the ISA wrapper and then divide it up. I don't know the answer to.
But is there any ISA relief if you transfer assets to somebody who's not a spouse or a civil partner?
No.
Yeah, so by definition, unless you have more than one spouse, civil partner.
Yeah. It would only, it would only be if you had a portfolio and you didn't want it all realising and you wanted it sharing in situ. That is possible.
Next question. Are children from a previous relationship counted as stepchildren, even if we married after they became adults?
Your biological children are always your children. Does that?
No, stepchildren. So yes, the answer's yes. So if I got married to somebody and they had two adult children, certainly for the purposes of the residence nil rate band, they would still be
Yeah,
classed as my stepchildren.
yeah.
Thank you.
Yeah.
Question about gifts out of surplus income with a regular pattern. Can you elaborate on how much that amount can be per annum or per month? What does a significant exemption look like? So a specific example in this situation is where a family member has had to give up their full-time employment to care for a family member with Alzheimer's and vascular dementia and is claiming carer's allowance only at present. Does that make sense?
Yeah, I think so.
Yeah.
There isn't really a ceiling on the amount. It is the two fundamentals are there has to be a series of payments, and you have to demonstrate it's come out of your spare income. You know, I earn £1,000 a month. I spend £750 a month. Therefore, I've got £250 a month spare. Therefore, if I give the person £100 a month, I can demonstrate I'm doing that. But as to the actual amount, I'm not aware that there is any ceiling. Let's be perfectly honest. If you've got to silly amounts of money, people are going to ask a lot more questions.
There is when you're claiming this exemption, there is an inheritance tax form which sets out a table which you are expected to fill in if you're trying to claim this exemption. So the table has it has sections for your income, so it wants to know where the income's from, a state pension, a private pension, and then it has a section for your expenditure, so house expenditure, mortgage, utility, holidays, and then it's one minus the other, and then you show what's left. And then you put in the box at the bottom how much you've made that year in the gifts. So when we're discussing estate planning with people, I would often print off this form and say, if this is something you're seriously considering, as Richard said, there needs to be a pattern of gifting, even if it's only, 3 times every year, you have a look and see. But I always say to people, use this form as your guidance. So if you can fill in the boxes as you're going along, you can then make the gifting. And of course, the other side of that is that then when you've passed away, your executors aren't trying to look back 8 years to see what the council tax was at that time and how much you spent on your utilities. So as I say, there is a really useful form which you can use to give you the guidance as to how much your excess income is in a year, and then use that to then plan your expenditure. But no, as far as I know, there's no upper limit as long as you have got the calculations to show.
I didn't know that myself. Thank you. Next question. Is there a limit to how many £250 small gifts are permissible per tax year per person?
No.
That was a quick one.
Simple answer.
Next question. What if you also have property or properties overseas? Does a will in the UK cover against that?
Ideally, no. We do sometimes do wills, and people want to include a holiday cottage, a holiday place in Europe. We do sort of caution against it, but there are quite a lot of countries that will recognise a UK will And if that will says it goes to my children, they will recognise it. We do try to caution against it because the laws, the inheritance laws in different countries are very different to ours. So you may be trying to do something by your will that you can't actually do in that country. So it's always better to take some advice.
Thank you. Question on enduring power of attorney. Question here. This person's partner and themselves set up a reciprocal EPA in 2003 and want to know if the law around EPAs has changed since then, and might there be a necessity to renew them in some way? 22 years later, with both of them around 80, are there new issues that they should consider?
Yeah, it's an interesting one, and it's a question which is often raised, I think. EPAs, enduring power of attorneys, began in the 1980s, and you stopped being able to make them at the back end of 2007. They were the forerunners to lasting powers of attorney. The first thing to say about them is they are still valid on that. The second thing to say about them is that whereas with a lasting power of attorney, they have to be registered before you can use them. With an enduring power of attorney, you can use them without registration. And the trigger for registration is either the person has lost mental capacity or is losing mental capacity. Enduring powers of attorney, they can only deal with financial matters. They can't deal with health and welfare matters. So possibly the first thing I'd be doing if I only have an EPA in place is to do an LPA for health and welfare. In terms of operation, the biggest difference is what we might call discretionary management of funds. If you land up with a pot of money, for instance, you've sold a house and you're going into residential care, you might go to a financial investment manager to invest the money. They can either manage that by taking your instructions for everything they do or on a discretionary basis. Unless they have specific power under an LPA to do that, they're going to be stymied in doing that. So I think, yes, there is some, if that is likely to, or if that is a possibility, then that would be a trigger for an LPA for finance. What do you feel, Belinda?
Yeah, everything you've said, I agree with. I suppose the only thing I would add to that is that there is just that extra flexibility, with having, a set of attorneys, and then a replacement set of attorneys if needed. So again, it sort of depends how your enduring powers of attorney are set up. For example, if you've got on there your spouse and your 2 children, provided they're all appointed jointly and severally, there's probably not a problem. But, some people made enduring powers of attorney purely appointing, for example, their spouse. And then, of course, you may run into a problem further down the line. So there's a little bit more flexibility with a lasting power of attorney, but equally, your enduring power of attorney for your finances may be absolutely fine.
And there's no reason why you can't have the 2 documents side by side.
Thank you. If you put your residence into a trust, do you lose 175 residence allowance forever?
Yes. Simple answer. Yes, it's only an allowance on death.
Thank you. On the question of pensions that we've touched on, what's the difference between making an expression of wish or a nomination of beneficiaries? The questioner has said that some pension providers seem to allow either.
Interesting one. I would say that broadly they are distinctions without a difference, but I may be wrong on that point. The thing is, because of the way most pension funds are structured, pension trustees have the final say in terms of what they pay to whom. And it has to be like that. There has to be that arm's length relationship in order to keep the pension outside of an estate. But certainly I have seen expression of wishes and nomination forms, but I wasn't aware that the fundamental aspect of either was particularly different. It's you're telling the pension trustees this is what I would like doing with my pension.
Thank you. Back to gifts out of surplus income. Does the 7-year rule apply to this as well?
No, it doesn't.
No. They're separate and distinct.
Yeah.
Can a beneficiary also be a trustee?
Yes.
Excellent. Nice quick question.
It's a very common question. People raise. Can I be an executor if I'm a beneficiary under a will? And people see there is a potential for conflict there.
We have a lot of questions, so I'm trying to get through things.
Can I just go back to that trust question and the residence nil rate band? I just want to make a distinction. If you put your house into a trust during your lifetime, yes, you've lost the residence nil rate band forever. If you are putting your house into a trust by your will, then the answer is different. The residence nil rate band may still be available. I just kind of suddenly thought there is two distinctions there. Sorry.
No, thanks for clarifying.
Yeah.
Another question. If you're married but live in different properties, in the event of death, will the spouse be the beneficiary? So still married, different properties.
Well, that depends, A, what you say in your will, and B, how you own the houses. There's two separate ways of owning houses. Firstly, joint tenants. I know it's a weird word when you're talking about ownership because we think of tenancies and renting, but tenant basically means a legal interest. If you own your house as joint tenants, the people with whom you own the person or the people with whom you own the house will automatically acquire your interest on your death. It passes outside of the will. If you own as tenants in common, it will pass in accordance with your will, or if you don't have a will, in accordance with the law of intestacy.
Thank you. What is happening to the tax nil rate bank? If I've already been widowed, would it be beneficial for me to marry again?
You can have more than one inherited nil rate band from two deceased spouses, can't you, Belinda?
You can. You have to do something a little bit clever with your will to use them both. But if you have been widowed for a lot of years, well before the transferable nil rate band came in, you can still claim that exemption if all of their estate passed to you. Yes, you can have more than one, but you do just need to make some adjustments in a will to be able to claim them both.
Thank you. Well, now we have got quite a lot of questions still to ask. Are you okay to stay on for a few more minutes, or?
Yeah. We're okay.
I mean, we'll do a couple more. Then we might have to, because we literally have another 10 or so to get through. So I think that's probably too many. But we do a couple more and then go back to the ones that we haven't been able to answer later on via email. Would that be okay?
Of course.
Yes,
absolutely.
we can do those. Yeah.
Yeah, definitely.
Okay, so how do UK inheritance laws apply to property and/or bank accounts outside the UK? Are the parts of the estate based abroad calculated into the UK taxable estate?
If you are resident in the UK, so you fall under the UK inheritance tax law, then the values of any assets outside the UK are included as part of your estate for inheritance tax purposes. If you end up having to pay some kind of inheritance tax also in the country where those assets are situated, there are what's called reciprocal tax arrangements between countries, so you don't end up paying tax twice. But yes, you do have to include those assets in a UK inheritance tax return.
But am I right? Well, there are lots of reciprocal arrangements. There aren't reciprocal arrangements with all countries, are there?
No, but there are a lot.
I think the message is talk to lawyers in those countries so you get a full picture.
Thank you. Can you put rental property into a trust, and would it attract inheritance tax exemptions? Does the value of the property's capital get added to your estate?
Well, I think I'm right in saying with a normal rental property, that would be treated as any other asset in your estate. If you put it into a trust, then it becomes an asset of the trust, and depending on the terms of the trust, whether you're doing it in your lifetime or after you've died. If you're doing it after you've died, it will be part of yours. A normal rental property would be part of your estate. If you've done it in advance, you're probably talking about the 7-year rule.
Yeah.
Thank you. Right, I think we'll leave it there for now, and we'll answer the rest of the questions via email, which I'll send to everybody in the next week or so. That's pretty much all we have time for today. We do hold this session twice a year. Our next one will be in June, and you're very welcome to come back and join us again. If you have any more questions, as I said, please let us know. You can email them to me or include them in the post-event survey. A link to the survey will magically appear when you end the webinar. It only takes a few minutes to complete, and we'd be grateful for your feedback, and you could win a free simple will. I'm also pleased to let you know that Crombie Wilkinson has generously offered a 12.5% discount on their will writing services, and details will be in our follow-up email. If you're interested, please get in touch with them to discuss your personal circumstances and let them know that you've come via YuPlan and the University of York. On behalf of the University of York and the Office of Philanthropic Partnerships and Alumni, I want to thank Richard and Belinda and all of you friends, staff and alumni for being here today. Enjoy the rest of your evening, and we hope to see you again soon. Thank you and good night.
Good night, everyone.
Thank you.